Supreme Court has held that under Section 24, wife's dependents are also covered.
Though she is a BE graduate, wife is unnecessarily creating issues from the date of marriage for having separate house. Even after many conciliation, wife has not changed her behavior and is threatening the husband to end up the marriage if separate house is not provided. 15,000 for the children and 15,000 to the wife would be an appropriate maintenance. Maintenance is enhanced to 30,000. Petition is disposed of with costs of rupees 50,000 to be payable to the wife.
Question is no longer res integra because the Supreme Court has held that under Section 24, wife's dependents are also covered.
Where is that?
The observation?
Yes.
If I may invite your ladyship's attention to para 11 of the impugned order. Para 11, your ladyship can find it at page 28 of the writ petition. If I may read, a bare reading of the above provision connotes that husband or wife can file an application for interim maintenance during the pendency of the petition filed under the said act. This provision is silent about the maintenance pending to the minor children under the similar provisions of other acts. Therefore, this court is not inclined to grant any maintenance to the minor child of the petitioner and respondent. The court proceeds to grant a maintenance of rupees 5,000 when the wife is unemployed.
Court has granted 5,000.
5,000.
Agreed with the orders passed in, whereby the court had granted 5,000 per month as maintenance to the wife and denied the maintenance to the children. Further, granted an amount of rupees 10,000 to his litigation expenses. The wife is before this court. MC 5196 of 2023 is filed by the husband seeking restitution of conjugal rights. In that, wife had filed an I number 3, seeking maintenance of an amount of rupees 60,000 per month towards interim maintenance of the respondent minor children and also for herself. It is a case that the children are aged 7 and 5 years and she has to take care of the child. Though she is a BE graduate, wife is unnecessarily creating issues from the date of marriage for having separate house. Even after many conciliation, wife has not changed her behavior and is threatening the husband, his parental family members to end up the married life if separate house is not provided. And according to the husband, he is drawing a salary of 1,05,000. His general monthly expenses are about 80,000. He spent rupees 45,000 per month towards the medical and other expenses of the dependent parents. And further, as a wife is competent to take care of herself, she is not entitled for maintenance. The court, by order impugned, had held that under Section 24 of the Hindu Marriage Act, the children are not entitled for maintenance. And the wife is employed. And the reasons that are stated for not working, see page now, SCC 7 at paragraph number
6.
The court has observed that Section 24 of the Act, no doubt, talks of maintenance of the wife during the pendency of the proceeding, but this section, cannot be read in isolation and cannot be given restricted meaning to hold that it is the maintenance of the wife alone and no one else. The court has, Honorable Apex Court has observed that her right to claim maintenance would include her own maintenance and that of the daughter. Relying on this judgment, and counsel submits that the order passed by the court needs to be set aside. Next para. This matter has come up before this court on several occasions. On every occasion, the matter came up. Land counsel for the respondent husband had sought for time. On 23/7/2024, this court has adjourned the matter at the request of land counsel for the respondent. On 23/7/2025 and directed the matter to be listed on 25/7/2025. Then again, when the matter came up on 25/7, asked for a passover, and as due to paucity of time, the matter could not be taken up. Again, the matter was directed to be listed on 28/7/2025. The petition will be allowed with cost of rupees 50,000. Today also, in the morning when the matter is called, listed under the head part heard. Today, again a request is made for a Passover. Though the learned counsel, the petitioner has opposed, considering the case of considering the submission made on behalf of the respondent. The matter is directed to be, then the matter is passed over. Again in the afternoon, there is no representation on behalf of the respondent counsel. Considering that it appears that the respondent time and again is seeking adjournment and taking the process for granted, and these kind of these kind of tactics will not work. Hence, having given sufficient opportunity, as discussed in the above paragraph, this court is inclined to pass orders on the merits of it. Having heard the learned counsel of the petitioner, peruse the entire material on record. There is no dispute about the fact why for not working, that finding of the court cannot be sustained. Then coming to this, that under section 424, children are not entitled. In the light of the law laid down in Jaspir Kaur Sehgal reported Supra, this court is of the view that when the mother is taking care of the expenses of the children, it has to include the children's expenses can also be sought in an application filed under section 24 of the Hindu Marriage Act. Then now what would be the quantum, the appropriate amount of maintenance for both the children and the wife, considering the salary of 1,05,000 the husband is getting. In the considered opinion of this court, 15,000 for the children and 15,000 to the wife would be an appropriate maintenance. Accordingly, the order of the family court is modified and the maintenance is extended. My maintenance is enhanced to 30,000. Accordingly, the petition is disposed of with costs of rupees 50,000 to be payable to the wife within 4 weeks from today.
Grateful.
क्या सच में पति को पत्नी के उन परिजनों का भी भरण पोषण देना चाहिए जो उस पर निर्भर है? क्या ये कानूनी और नैतिक रूप से सही है? अपनी राय नीचे कमेंट में जरूर दें। कर्नाटक हाई कोर्ट की इस कार्यवाही में पत्नी ने अपने मेंटेनेंस की राशि बढ़वाने की मांग की। उनका कहना था कि उनके पास कई जरूरी खर्चे हैं और उनके बच्चे पूरी तरह से उन पर निर्भर हैं। पति की ओर से बताया गया कि पत्नी उसे और उसके माता पिता को लगातार धमका रही है कि यदि उसे पति के साथ अलग रहने की व्यवस्था नहीं दी गई तो वह विवाह तोड़ देगी। लेकिन पति अपने माता पिता को छोड़ना नहीं चाहता। दोनों पक्षों को सुनने के बाद न्यायालय ने पत्नी के भत्ते को 5,000 से बढ़ाकर 15,000 कर दिया और बच्चों के लिए अलग से 15,000 प्रति माह निर्धारित किया, क्योंकि पति की आय 1 लाख से अधिक है। साथ ही पति द्वारा कई बार सुनवाई टालने के कारण अदालत और याचिकाकर्ता का समय नष्ट हुआ। इसलिए अदालत ने 50,000 का जुर्माना भी लगाया जो पत्नी को अदा किया जाएगा। फिलहाल के लिए बस इतना ही। इस मामले की अगली अपडेट जल्द लाएंगे। धन्यवाद।